This is the beginning of clip 4. NAFSA proceeds to look at the standard of review that is to be used by the Labour Court when reviewing a CCMA award. And in this regard, NAFSA says reasonableness standard, or the standard of reasonableness, was dealt with by the Constitutional Court, and correctly so, in Barter Star, where Barter Star drew the important distinction that we have to make between a review and an appeal, and it is only in a review where we have a decision that a reasonable decision maker could not reach, that if that factor exists, that the court then has essentially jurisdiction to interfere with the way in which the discretion was exercised. And NAFSA says Carphone versus Marcus was authority for the view that in terms of a review brought under Section 145 of the Labour Relations Act, Carphone held that Section 145 of the LRA was suffused with the then constitutional standard that when dealing with an administrative action decision, i.e. such as administrative action that takes place on the part of a commissioner at the CCMA, that the decision must be justifiable in relation to the reasons therefore. NAFSA has a problem with this because essentially what Carphone versus Marcus is doing is it's saying that when reviewing a CCMA award, you must suffuse your labor relations review with the administrative law provisions, i.e. Those provisions that then existed under item 23(2)(b) of Schedule 6, as read with Section 33 of the Constitution, i.e. rationality. But NAFSA says the more intelligent approach is or the better approach is that Section 145 of the Labour Relations Act, and for that matter Section 158 for the Labour Relations Act, must be suffused with the constitutional standard of reasonableness as established in Barter Star, i.e. is it a decision which a reasonable decision maker could not have reached? And if that is the measure you're using, and you decide, you come to that conclusion, then that opens the gateway to judicial review. So if you apply that standard to the facts of the Sodoma case, NAFSA says that the commissioner gave 3 reasons regarding why the sanction was appropriate. Firstly, the company, Rustenburg Platinum Mines, suffered no losses. Secondly, the misconduct was not intentional. And thirdly, there was no indication of dishonesty. And NAFSA says this is one of those cases where the decision maker acted reasonably, or put differently, it cannot be said that his conclusion was a decision that a reasonable decision maker could not have reached. So that's the finding of NAFSA, and agreeing with NAFSA or concurring with NAFSA is Moseneke, Medala, O'Regan, and van der Westhuizen. So the Sodoma case is important for 3 reasons. Firstly, it says that when looking at what is fair in terms of the dismissal of an employee, you don't defer to what the employer regarded to be fair or as fair, but you approach the dismissal from the ambit or lens of Section 23(1) of the Constitution, i.e., and in terms of the Nahau versus UCT Concord decision, what is fair to both the employee and to the employer. Secondly, your standard of review has changed. It's no longer Carphone versus Marcus. Is the decision justifiably related to the reasons given therefore? Your standard of review is now changed to ask to the question, is it a decision which a reasonable decision maker could not reach? Because if that is your conclusion, then that is a basis on which you can interfere with the award handed down by the CCMA Commissioner. And why is this relevant to administrative law? Because that leads us to the third point made in the Sodoma case, that all compulsory arbitration hearings conducted at the CCMA, which is a creature of statute in terms of Section 112 of the Labour Relations Act, constitutes administrative action. So those are the three important things you need to remember from the Sodoma case. And in paragraph 139 of the concurring judgment by Cato Regan finds that the CCMA is an organ of state. So those are essentially the three factors that you need to keep and bear in mind when reading the Sodoma case. This is the end of this tape. Thank you.